is that this is a two-humped camel. So the first hump was today, and that could have been it. It could have been over had the court struck the entire thing, but they chose not to do so. So the second hump of the camel today was decided, does the federal government have the power? What was not decided today is, do Ohioans nevertheless have a right to be free? So that's a second-tier analysis that wasn't decided. So what we do is argue in federal court that under the Healthcare Freedom Amendment, Ohioans have a right to be free from the mandate. What we also try to do is stop any kind of Obamacare exchange from being implemented in Ohio by the administration or by the state legislature between now and November, under the premise that if we can get to November, and I guess, far be it from us to have Mitt Romney as our last best hope, but if he were to prevail, that we could stop Obamacare that way. So let's not get the wheels turning too fast between now and November.
The Attorney General just said that he thinks that that the constitutional amendment cannot stand in the way of the federal law, and that if there is a court challenge, he'll be on the state side.
Yeah. Well, the state side means that he defends the state constitution. So presumably he's on our side, if that's the case. If he takes the other side, I think he'd be abdicating his duty.
What kind of a legal argument could you make for state constitutional amendment overruling a federal law?
Yeah, that's a great question. And we've discussed this before in some of our press conferences, but it's been a while. What we've always argued is that substantive due process rights come from state rights. In other words, if a state law protects your liberty in some way or another, that's a liberty interest under the 14th Amendment of the federal Constitution, and that's something called substantive due process. So the notion is Ohioans have a liberty interest to be free, and then we do the substantive due process analogy. So our argument is that we've federalized the right by putting it in the state constitution and some of the language we use to create a liberty interest. So that's what we'll be arguing in federal courts. And if you may have noticed, in the Sixth Circuit, Judge Sutton was open to that view. He expressed the notion that if this was a due process case, these people might have a better argument. And that's, of course, exactly where we'll be going, is to the Sixth Circuit.
Is there any legal precedents that...
Yeah, so the best case on our side is there is a substantive due process right to not be forced to purchase, or to not be forced to receive medical care that's unwanted. So you can't have forced medical care. So our argument is simply a minor extension of that, which is not only cannot be forced to undergo medical treatment, but therefore you can't be forced to pay for medical treatment that you don't wish to undergo. So that will be the argument.
So wait, let me understand. You are going to go into federal courts and insist that Ohio's constitutional amendment, the voters okayed, should still be let Ohio exempt itself.
No, not quite. This is an important distinction, and it's hard to do in a soundbite, but there's something called an as-applied challenge versus a facial challenge to the constitutionality of the law. What we probably don't have is a good facial challenge, that the federal health care law is unconstitutional facially. We don't have that. What we have is the argument as applied to Ohioans who don't want to purchase insurance. They have this state constitutional right that arises to a federal substantive due process right. And so that's what we'll be arguing. So will it exempt everybody in Ohio? No. It's kind of a one-by-one. The court will make some sort of a narrow exemption, we hope, that people can fit into if they don't want to buy insurance.
Do you have to wait until 2014 until the requirement kicks in? Or?
We think the case will be ripe now, just like the challenge that the court decided today was ripe now.
Okay, so what's the step? Are you filing now, or what's the plan?
Well, we didn't want to do work that wouldn't matter, so we haven't started yet. We've done the research as we've gone along. We did the research to pass the Healthcare Freedom Amendment because we want to make sure that we set it up right so that we could do this if we had to do this. So we set it up right. We made sure that on Ohioans' balance it said that the right to not be forced to purchase health insurance is a fundamental right in the traditions of ordered liberty, which is kind of the magic words needed to create a substantive due process right. So you might remember that on the ballots in November. So we did try to set this up, and to use a pun, we tried to buy some insurance that this might happen. So we'll kind of begin to get more serious about that work now.
And where would you file?
Oversimplifying it.
Like boil it down.
But oversimplifying it, what you're saying is you're not going to use the constitutional amendment to try to overturn the federal law. Obviously, the courts said that.
Right.
But you are going to try to use it to let at least some Ohioans exempt themselves from the purchase requirement.
Well, it's to protect Ohioans who don't want to purchase health insurance from not being forced to purchase health insurance. That's right. And the case is always better if it's a healthier person, if it's a younger person. So we've got clients like that who don't have health insurance, people that believe in natural foods and natural healing instead of traditional medical care, prescription drugs as the proper way of life for them. These people would never purchase insurance. The Amish, although they're exempt under the federal law, but people kind of like that will be the starting point. We're probably looking. Most of our clients are in the Southern District of Ohio, so probably looking at federal court there. I mean, this is probably a ways off, to be clear. We don't have a complaint ready to go right now, so we're probably.
You're looking at federal court
yeah,
on this
right.
one, even though it's a state constitutional amendment?
That's right, because our argument is that it creates a federal right, a substantive due process right under the 5th, 9th, 14th Amendments.
Okay, and to follow through with your argument, let's assume you're successful in preventing Ohio from implementing the exchanges. Can you be successful in preventing the federal government then from imposing an exchange on Ohio?
No, absolutely not. So the notion is that the state, under the state constitution, does not have the power to impose an Obamacare exchange. The federal government, we can't stop the federal government from imposing an exchange. The difference between the two, however, is dramatic. One is a pragmatic difference. That is that if the federal government has to do something from afar, we think we have a better chance of making the law collapse because it's going to be harder for the federal government to enforce from D.C. The second is an important legal issue, and that is that the premium assistance, again, sorry, this is hard to do in a soundbite, but there's a glitch in Obamacare, and that is the premium assistance that's available for a state exchange is not available, the subsidies, that's right, for individual health insurance purchasers who don't currently have it. That's not available under the federal exchange. It's only available under the state exchange, which means you also can't tax the employers to get that premium assistance under a federal exchange. So the whole thing, again, if the federal government's forced to run all these exchanges, it turns out they can't run them, and Obamacare has to be reopened for amendment, potential repeal. So our best chance is to keep Ohio from implementing an exchange.
So your basic message is to go slow for Ohio to not implement the exchange now because, first of all, you've got your court suit that could change things, and I guess politics could also change things in the election.
Well, we hate to think about politics over at 1851 because we're nonpartisan and we don't like the Republicans any more than the Democrats most of the time. But on this occasion, Mitt Romney has made it clear that that's his top priority is to repeal this law in November. So it would seem foolhardy for members of his own party who run the state to rush in and start an Obamacare exchange, which does nothing but really, really help preserve the integrity of Obamacare and make it harder for Romney to potentially undermine it. So by starting an exchange, the Republicans would essentially be delivering Ohio to Obamacare on a silver platter. But that's something that could be extremely avoidable if we're able to hold off until November and we get a favorable result in the election.
Do you have to wait for Ohio to take some kind of an action in developing an exchange before you launch this legal challenge?
We do. So right now, to my knowledge, the Ohio Department of Insurance has taken a grant to explore, basically, and to kind of plan out what an exchange might look like. They haven't returned that grant, but they haven't done anything besides that. And we don't think that's a substantial enough step that they violated the state constitution at all by doing that. So there'd have to be more of a substantial step in support of an exchange. And the reason for that, by the way, is the exchange violates the terms of the Healthcare Freedom Amendment. By imposing the exchange, they would actually be violating their own state's constitution. And while the federal government may be able to do that under the Supremacy Clause, state officials can't do that. The state constitution unquestionably binds state officials.
So passage of a law to authorize implementation of an exchange, would that be your trigger, basically?
That's probably the trigger, yes, because by authorizing the exchange, you authorize everything that the exchange requires, which is enforcement of the mandate by state officials, limitation of healthcare choice, and options as required by the amendment, the Healthcare Freedom Amendment, and all that carried out by state officials.
So no purely administrative action would be good enough to trigger your like internal preparations and stuff within ODI?
I think we need a law to challenge.
The Medicaid expansion, the